This was a report. It has no legal significance, but it is the report that we based our policy that came out after that on. What became the original legal document for our policy was a Gazette notice that we issued in June 16th of 1990. And what it says is, the purpose of this notice is to advise all interested parties of the policy of the Department of Communications with regard to the authorization of radio communication systems and associated antenna structures. And it goes through the usual preamble, and it ends off with, under the new Radio Communication Act, the Minister of Communications is authorized to take into account not only the spectrum management considerations, but also environmental and land use factors in granting radio authorizations, to ensure that local views on these topics have an opportunity to be heard and balanced against radio communication needs. Applicants for systems, and here's a key phrase, involving significant antenna structures will be required to notify and consult with appropriate municipal authorities. Now, that was the policy statement, and from that we were required to come up with an operational policy document. We came out with the provisional document, which you may have heard of, in February of last year, which went through the public consultation phase, and it included what we call our environmental assessment process, but with that was our municipal consultation process. And I think a lot of the problem seemed to be is that we were not clear into exactly what we were outlining in this process. In this process, there are two very specific types of authorizations of radio installations. One of them is what I would refer to as the business class, and that's basically the private commercial users and the public commercial companies, and basically everyone out there that is doing something on a business basis. And what we say in that process is that they are required, as part of their application, to consult with the municipalities and provide an attestation to this effect to the department with their application. What this means in reality is that before we issue a license to those individuals, we require to look at this attestation form, which is included in the document, to determine that they have done municipal consultation. Other things may fall out of there and what we may require them to do before we issue a license. But the aspect of this that's very important is these are installations that we issue a license for a specific radio station or facility located at a specific site. There is the amateur radio operators, which fall into the other class of radio installations. And with amateur radio operators, we do not issue a license for a specific radio installation or site. We issue a license that allows you to operate your amateur radio station. What we've said in our consultation process, and I think it's important when, just to interrupt myself, it's important that the statement in our notice of 1990 is reflected here. We refer to significant antenna structures, and we have not anywhere attempted to define what a significant antenna structure is, because I don't believe we can or should. But what we've said is that amateur radio operators are required to consult with the municipality if they believe the installation of their supporting structure or antenna is going to lead to local concerns. And that is the requirement we put on the amateurs. Now, we have already issued, in most cases, we have already issued the amateurs a license prior to them putting up an antenna structure. Therefore, we have already issued the highest authority that we are mandated to do under the Radio Communication Act, and that is to issue a license. With the other group of users, going back to the business users as I referred to them, this is not the case, because they are issued a license after the fact. That is, after we have reviewed their application in entirety. Therefore, when you are in a situation where you have consulted with the municipality and a problem arises, we have already issued you a license. And what we say is it is incumbent upon you to consult with the municipality and attempt to come to some kind of reasonable understanding. Now, of course, the question arises, what if you can't come to a reasonable understanding? What if the municipality is being unreasonable? Our process, whether this makes sense or not, is built upon the premise that people will do reasonable things and reasonable accommodations will be made. Now, this doesn't always happen, of course, and we do not get involved as a department in determining the rightness or wrongness of your amateur installation. We have issued you a license. You have already received the document that authorizes you to operate. What we say is, if you choose to go against municipal bylaws, then that is your responsibility. You are the ones that have to bear the consequences of your action or decide whether that is the route that you want to go. As far as the department goes, we do not get involved because there is no reason to us to get involved. As far as the Townsend report goes, we believe that there's federal paramountcy in the area of radio authorizations. Municipal bylaws that are prohibitive are ultra-virus in this case, and we don't believe that there is any, I guess, waffling or whatever you would say in that regard. That is our understanding of the situation. I go back to the business people as an example. With them, we require them to go through the attestation process, which may mean before we issue them a license, they may have to make alterations to what they're going to do or look at other alternatives or etc. It's a case-by-case thing, so there is no, you can't say 100% of the time what they would have to do before we issue a license. However, they arrive at exactly the same point as you do if there's a conflict with the municipality. We issue a license, and it's up to them to decide whether they want to go ahead and erect that structure against the wishes of the municipality. We say, we've come to the end of our road here, we have paramountcy, here's your license, go out and perform as you see fit. And that is the big difference between amateur radio operators and the other types, is the fact that they have to go through this attestation process and you don't. You are essentially pre-approved. At this time, I don't believe we have any intention of changing our policy in this regard. Now, of course, I can't speak for the highest levels of the minister. Maybe events will transcend and it will be required to change our policy. But basically, what it means is you're either in or out of the attestation process. In other words, there is no such thing as I'd like to come in because I feel I might have a problem this time and I'd like to get some kind of ruling on the department. The process doesn't work that way. Amateurs are licensed and they're not licensed for specific installations, and it's up to them to determine how they want to go ahead.
Tom, when you're through, I'd like to question you on that.
Okay, go ahead. We'll stop there then.
I don't really think the question is site sensitive. I think it's got anything to do whether you're a commercial or whether you're an amateur. It's whether or not you have the right to use radio. And if you have a right to use radio, does not the department have a legal obligation to protect their jurisdiction that is defined under the Act and how it's highlighted in the Townsend report? That's the point. It doesn't really matter whether you're commercial or not. You can't use an amateur radio station without an effective antenna.
I agree with you that the department has an obligation to protect their jurisdiction. And I would be willing to bet that when that point arises somewhere in the process where the department's jurisdiction is challenged, we will protect our jurisdiction. We have not reached that point yet. What has happened is the municipalities may tell you that it's against one of their bylaws to do whatever. What we are saying is we have the ultimate authority. We have paramountcy. Once we issue a radio station license, that is the end of the ball game as far as we're concerned. Therefore, until we reach a point where a lower court or some court has come to some decision to overturn that or to question our authority, it isn't a matter of a federal challenge, because we don't believe there is a challenge there. That's the way it is.
I think it goes deeper than that. You're probably aware in New Brunswick where there's a gentleman, Mr. Bill Fleur. I forgot his call sign. I think it's 51 AUA or something like that. He went through the process and he eventually had to file a variance on a bylaw, which was going to cost him $150. And he was told by the regional manager, Mr. Landry, that it would be in his best interest to pay the fee and file a variance. And this is a variance on height. And it says right in the Townsend report that they have no control over height at all. Why would an officer of the DOC be telling an amateur that he has to go against the law of the land? Why does he have to subject him to that kind of procedure?
Well, that's a very good point, and I certainly think that I have to take, or my section has to take, some responsibility in the fact that that our policy is not clearly understood by everyone out there, including our own staff that have to deal with it. And it's unfortunately, I think our officials try to do the best job in certain occasions, or try to help out in certain times by giving advice that possibly they should not get into, areas they should not get into. In no way, shape, or form do we want to tell the amateur operator that it would be in his best interest to, you know, decrease his height or this or that or this kind of thing. That is between him and the municipality. If the municipality, for example, has passed a bylaw which is prohibitive, then we don't see any reason that an unreasonable bylaw that the amateur should necessarily abide by it. But again, that has to be up to the amateur and the municipality, because until such a time exists as federal jurisdiction is being challenged, the situation isn't a problem as far as we're concerned. We have issued a license.
Wash your hands, right? Yeah, you're on your own, Mac.
Go ahead.
These MPAR parts. I guess in the case of Burnaby Municipality, we had a case where they tried to regulate the use of the antenna, and that doesn't fall under their jurisdiction. And municipalities are very rich because they have the taxing authority. They have unlimited funds. They can drown you out with dollars, where the poor amateur only has limited funds. So to send an amateur up against a municipality is not fair, because they can overwhelm you with their power and what have you. And until somebody speaks up and talks to them from a higher authority to make them understand what their jurisdiction is, we're going to be caught in this mess. We've got municipalities in some cases who don't care, and we've got others like Burnaby, and I know where Burnaby's coming from. And I'll borrow the famous expression from my former boss, Jerry Vernon. You look down Kingsway, and those buildings are festooned with antennas, is his favorite expression. And I know why they're upset. But that, you know, and so what happens is they take it out on the poor amateur. Because Rogers has the ability to fight the municipalities, and us hams don't have the ability to fight the ham. We don't have the national ear that Rogers has of your organization. You know, we're a few people trying to do a thing. And your people have not, I will stress, have not communicated to the municipalities, despite what you've been told. You have not. I met with your people here in Vancouver. I have met with the GBRD. I am the chairman of one of the largest improvement districts in the province. I went to my superior, Bill Brown, who the building inspectors report to. He has heard nothing, absolutely nothing from the DOC about this. I then went to an alderman who worked for me before I retired. They took it up with the municipal council. They have heard nothing. There's a big communications gap out there going on, and people doing things that they don't know what they're doing, and it's going to take your help and your leadership to help bring this together. as to what is supposed to be controlled and what isn't. And one of them is height and use of antennas and that sort of thing.
Okay, I guess if I could respond to your question, if I can, each part, I agree with you. From our point of view, the municipality has no jurisdiction over height, use of antenna, etc. There's federal paramountcy there. I also would agree with you that not in all cases, but in some cases, we have not done a good enough job of communicating our message to the municipalities. And we are attempting, because of situations that have happened, like in Vancouver, we're attempting to do this at the level of the FCM, the Federation of Canadian Municipalities. I would have to point out that we have no jurisdiction over what a municipality may enact as a bylaw. We cannot tell them, no, you cannot do that. You cannot enact that bylaw. We can tell them what we understand the legal significance to be, what we understand the legal situation to be, etc., etc. But we cannot say to them, you guys can't enact that bylaw, because we have no authority to do that.
There is an office in the city of Vancouver under the UBCM which guides all municipalities and bylaws. Like the municipalities go to the UBCM office in Vancouver to get guidance on the preparation of bylaws. Have you communicated with them?
I believe that there is as reasonable.
Have you attended the conference of building inspectors in the province of British Columbia? Because they're the ones that issue the building permit.
I believe 3 days ago, we did send a letter to the Municipal Association. I could take out the letter for you. It's sent out by
the interpretation of CPC is wide and it's loose and it's being, just giving us nothing but hardship.
I think one of the problems with the CPC, which I agree with you, is that we do not state the case strongly enough of federal paramountcy. We allude to it, and as in all good government documents, you like to allude to things. But I believe that this is something that has to be fixed up. I agree with you. I think it has to be brought right out in front and stated.
We're in an era, you brought this about in the era of public consultation. Did you consult with the HAMs before you issued that document?
There is a process that we go through, and it's called the Canada Gazette process, as you know. Now, that is not, it doesn't, I realize that process doesn't reach everyone, and there are a lot of holes in it. But that is the federal government process, and I had exactly the same comment that you have just made brought up to me about a year ago by the Radio Advisory Board of Canada, who were madder than hell, and they said to me, you didn't consult with us. The municipalities have said the same thing to us. This is a far-reaching document as far as who it touches. And whether you agree with the federal government process for consultation through the Canada Gazette or not, that is the vehicle that we use. I don't argue that one could always say we should have done a better job at the grassroots level in retrospect, and I think that's what we're trying to do now in hindsight, to fix things up. But again, it's a big country, and I have no control over the process that the federal government uses. You have to abide by that process in these type of situations.
My shirt and show you my scars of being chairman of an advisory planning commission for 3 years. I don't disagree with the public consultation. It has to take place, but then you have to get everybody in on it. You can't have selected groups in on your consultation process. The process has to include everybody.
And you have to be very careful too that you are not seen in a public consultation process as providing information to select groups as well. I mean, it's a fine line you're walking. I can't sit here and defend the Canada Gazette process and say that this is the best way to go. There shouldn't be changes to it. At the moment, it's the way we do things. And if you want me to concede a little bit, I will say I agree we should have done more grassroots work on this in the beginning.
Tom, I think if you're going to revise a policy paper, I think it's got to be very explicit and very upfront right away what you do stand for and what you believe the federal jurisdiction is in some simple terms. Otherwise, this continual misunderstanding is going to go on. You do stress the environmental issues and the right of Canadians for environmental protection, but you don't stress the right of Canadians to use radio.
Okay, I suppose it's I mean, it's a good comment because I read the document from a person that's, you know, involved in getting it together. I guess I take things for granted that aren't there. And if you, as the general public, read that document and it doesn't communicate that to you, then there's a problem with the document. There's no question. Yes?
Yes, John Wright, B7BBW. Just to clarify a point that a couple of words that you said before, that the municipality does not control the height or usage of the antenna. Well, if that is so, they have no jurisdiction over the erection of that or the structure. If they don't, they must do, because they're not letting you put it up in the first place.
Well, again, you're getting into a jurisdictional dispute. If I can say to you, you know, you can't do something, and I may be an officer of whatever, you know, I may not be just a private citizen, I may be seeing this through whatever auspices I'm involved in. However, if I have no legal authority to say that, then what is my statement worth? And what we have said in our policy, and what, as I was trying to lead up to how this thing developed, is it is our position that there's federal paramountcy as far as antenna structures go in radio communications facilities. That municipalities, whatever bylaws they make, come in at a much lower level, and they're ultra-virus as far as they're applied to antenna structures. At the same time, we have said they should have, and this is a policy, and it goes back to our policy statement of 1990, we have said that they should be able to have some influence in determining what goes where. Now, the word is influence. It's not a decision or a veto or whatever. It's influence. Now, this is what our attestation does for what I call the business users. It gives the municipality a chance to express their views. Whether or not we may issue a license to these people regardless of what the municipality has said or whether they come to agreement or whatever. We may not. We may say the municipality has some concerns here that seem reasonable. What were you people willing to do to address that? But that is totally different from the position you people find yourselves in, because we do not bring you into the attestation process. You are issued a license. And in our hierarchy, that's as far as we go. Once you have a license, you are legally able to install your radio station.
And an antenna.
And the antenna.
No, but I'm trying to get a reasonably direct answer to the fact that you made the statement that municipality does not have control over the height or usage.
Mm-hmm.
And I say if they're putting these bylaws in, they do have control.
Well,
You're saying not, but they do.
well, what if they're putting in a bylaw that's ultra-virus from our perspective? Now, I realize what you're saying is they're telling me I have to do something, and I can't just tell the municipality to take a hike because I live in this area and I should try to abide with them. What I'm saying is, from our point of view, they do not have any right to tell you that you have to do this. However, in our process with the business people, even though they don't have a legal right, we're going to take their views into consideration. From your point of view, if you choose to say, well, I'm gonna go along with the municipality because I feel I should do that, that's your decision. We're not telling you you have to do that. You're the one that has to make the decision as to what you want to do.
My name is Dave Johnson. I live in Vancouver, and I went through the whole process of applying and getting turned down. They sent out letters to the neighborhood and said, "Do you like this or don't like it?" And I went through the Board of Variance situation with Vancouver, and sat there in front of 5 people who said, "No, it sticks up above the housetops. We don't like it. Take it down." So this was in September. They sent me a letter and said, "You've got 30 days to take it down." So I sent them back a letter, and my final trump card basically said, "You don't have the authority that Department of Communications does," and I haven't heard a thing from them since. However, they could have sued me, and may still. I don't know what their thinking is right now. Maybe they're just going to ignore me forever. But if they had come to me and said, "You're going to take it down, or we're going to sue you and make you take it down," would the Department of Communications come to my defense? Because obviously they have no jurisdiction over that sort of thing, considering the document. And if that's the case, I think maybe the whole crux of the problem here is that if you were to come up with a definition, even if it's a little loose, as to what is reasonable, then you would have the problem 99% lit. Because right now, we went back to them and said, "Give us an option. What do you want? What would you like to do?" Take it down is the option. So there was no in between. It's like, get it below the rooftops or take it down. And without a definition as to what hams need to get on the air with it, the city people, I don't blame them. They have no idea what's required. And they're going to try and make their law stick. So I guess my first question here is, if I was in the court, would you come to my defense?
I think the first answer to that is no.
I want to interject something for your edification, because I find the local office is not right up to speed regarding municipalities, regional districts. I might point out the city of Vancouver has its own charter. It doesn't come under the municipal act.
Okay.
You say no, Tom, but don't you have a legal obligation to enforce the act?
Yeah.
Yes. Okay, now.
I'm not a lawyer, but I understand there's such a thing as a writ of mandamus, which we can take to the government to try and get them to carry out their own legislation, enforce their own legislation.
Now, the first, and I'm not a lawyer either, and I to answer your question, I don't know if I fully answered your but yeah, I guess that was the answer. But you have to be, when you talk writ of mandamus with the federal government, you have to be very careful, because to license or not to license radio stations is ministerial prerogative. The minister may license, which means the minister may not license. And I'm not trying to give you a legal answer on exactly that question, because I can't. But to the best of my knowledge, no, you cannot issue a writ of mandamus against the federal or the Department of Communications in this matter, because it's a prerogatory thing. In other words, to issue a writ of mandamus, it has to be you have to do this sort of thing. That's not very good legal language, but and that's not the way our act is written. It is at the prerogative of the minister whether they will or will not issue a license.
But he's already got the license.
Yeah.
You've already exercised the prerogative, and you've given him the license. Now you're turning around and saying, okay, now you have to go to court in order to go find out whether you can put up a tower.
Well, first of all, I guess this is a good case. What we're saying is we do not have a problem with this situation, because as far as we're concerned, what the municipality is doing is not legal.
But if you represent us and they're telling us no, well, aren't you telling us then we're employing you for nothing? That's what it is.
Everybody said the license either. Yeah.
What?
Why are you collecting our license fees if you're not going to take it? I haven't failed mine yet.
you are in a situation, whereas I guess to address the first question, you're saying, are we going to go after the municipality because they are picking on you in something that we consider they're doing something which they don't have the legal authority to do? And the answer to that, again, is no, because as far as we're concerned, that is between you and the municipality. If you choose to erect a tower, that's fine. You're licensed as far as we're concerned. What else falls out of that as far as objections from people that are going to sue you for whatever reason, whether it be the municipality or others that are going to sue you for whatever the reason may be, we're not going to get involved in it.
Sir, could you put up a flagpole? I mean, like 150 feet high. Just because it happens to have a little tri-bender sitting on the top of it, would that be legal?
Well, that is an excellent question, and you can bring that to the point of view: is the CN tower an antenna supporting structure, and therefore does the Department of Communications have jurisdictional authority over it? I don't know on a case-by-case basis. I think what you would find with the legal interpretation to this is it would have to be something that reasonably applies. And an example is, what if you've got a silo that's 300 feet tall at the end of a private runway, and it's required to be marked for whatever reason, and you put a tri-bander antenna suddenly on top of it, and then it becomes our jurisdiction to ensure that somebody does whatever has to be done from a marking point of view. And I think legally, no, that would be considered to be an unreasonable circumstance.
DOC, are they willing to send some sort of information to the municipalities, or am I going to be trying to run my HF rig off a rubber ducky 2 years down the
road? We have sent information to municipalities before on this subject. Obviously, it wasn't received by a lot of them, or they didn't pay attention to it, or whatever. We're trying that approach again through the Federation of Canadian Municipalities to explain the position as we see it. And again, we cannot tell municipalities that they cannot enact bylaws. We can tell them we consider their bylaws to be ultra-virus. We can tell them our opinion. We can send them paper till the cows come home. But if they want to enact bylaws, we have no legal jurisdiction to say to them, you can't do it.
Isn't there somewhere in our regulations that stipulates we're not supposed to go over 60 feet?
No. No, you have, what you do is you have certain, and it's Transport Canada has jurisdiction within 2 kilometers of an airport or something like that, as far as the height of antennas and structures and this kind of thing. But that's a very specific, it's in their standard obstruction markings document, and I couldn't recite it to you chapter and verse, but that's a very, very specific incidence.
Well, Tom, it's interesting. You had this V7 CZV. You had said earlier that when the Department of Communications feels that their jurisdiction is challenged, they will do something about it. So does that mean that this is an interesting possibility? But does that mean that the amateur or the person or the commercial user as well, if they put something up, and and you're saying that the DOC doesn't get involved in other than the regulation of how the person is transmitting, but if they don't get involved at all, then does that mean that when the amateur goes to court or stands before whatever tribunal, that the DOC is not going to stick up for itself and advise that this is ultra-virus? In other words, you aren't even going to bother to get off the proverbials and tell the court or anybody that it's ultra-virus. That's what you're actually saying.
What it amounts to is they consider it that it's their opinion how high you can build your antenna, but it's up to you to prove that it's their opinion.
Yeah, that's.
DOC
into a specific incident, and I can't say exactly what would roll out. Certainly, the DOC would be called upon, I'm sure, to, as expert witness or whatever you want to call it, or to provide their expertise in the case, and obviously we would show up. But what I'm saying is we would not get involved in a legal case or a legal, the legality of the law until it came to a point where we considered our jurisdiction had been overturned by a lower court. Then I'm fairly certain that we would appeal the case.
So we have to lose the case first before you want to get involved.
Well, that's basically, I guess, what I'm saying. But again, you are outside of the fact that you are amateur radio operators, and as you say, probably don't have the means of some of the bigger companies. The exact same situation exists right now for anybody else that's putting up an antenna.
But we were here first.
Well, there was probably some argument in that, but I won't get into that.
B7WGA. You said earlier that you wouldn't get involved unless you felt challenged. And yet you say when the municipalities make bylaws, that's their business, even if it's a challenge. They look like challenges to me.
Well, what I'm saying is we have no legal authority to tell a municipality they can't enact a bylaw. Now, we will tell them our legal opinion. We will tell them the situation as we've seen it, as I describe it. They can say to us, tough, we don't agree with you. We think that we should have some say in this matter, and we're going to do this. And we do not have the legal authority to tell them, no, they can't do it.
So in other words, if the municipality of Burnaby or Vancouver or anyone else decided that we're not going to honor Canadian money anymore, we're going to coin our own money, the federal government's going to say, oh, well, we can't do anything about it, go ahead and do that. Is that right?
Well, I don't know. I'm not in finance.
It sounds like you're sitting on the fence to me. I'm sorry.
So for $23, we've got the legal right to go to fight with the municipalities. Is that right?
That?
Brian Langdon, B7QH. I have an antenna structure at home which, with its quad antenna on top, stretches up 55 feet into the air. I also have a certificate signed by somebody in your department which approves it and says it's okay. Now, my question is this. If some of my neighbours decide they don't like it and they do a bit of lobbying and West Van municipality passes a bylaw saying that they don't want any antenna structures in West Van or nothing over 30 feet or something like that, will you be willing to, as an expert witness or somebody from your department, to assure these people that their bylaw is ultra vires? Because apparently, from what we've heard, communication via the Gazette is a kind of a theoretical thing which doesn't do very much. And they need having it drawn to their attention. So would you be willing, for example, to issue an official notice that clearly comes from the DOC, making it clear that it is an ultra vires act of a municipality to regulate the height of antenna structures? We could just, it needn't be directed to them, you needn't even write a special letter, so long as we have something that we can say, look, you may be unaware of this, but here is the situation.
First of all, I would agree with you. It should be clear in our CPC, which obviously it isn't, that we consider this to be an ultra-virus activity by municipalities. That should be clear. Secondly, when you say you have, your antenna has been approved by someone in our department, I'm not exactly sure what you mean.
I have a form which I was advised to submit, and I did, and it came back with a signature on it.
Okay, well, I won't pursue that.
Yeah.
Okay.
The point that we're trying to get across, because you say that you can't stop municipalities making bylaws. I agree, you can. But you can at least let them know, in the politest and diplomatic terms possible, that you consider they're making a law that's self-required. And just leave it at that.
I agree.
That's what we want to see. We want to see you guys hanging your hat out the door.
Okay.
You know what I mean? And saying, hey, We can't stop a municipality, but we can sure tell them where it's at from our perspective.
And again, I go back to our CPC, that should come out clearly in our CPC, which obviously it doesn't. So there's one aspect of what has to be changed.
It's too vague, it's too general.
Yeah, okay. Well, you're right then. I guess you had another part of your question, which I can't remember now, so, okay, anyway.
I guess the message here, and I have to agree with Holly and Ryan, is how soon? You know, like next Monday would be fun.
Hugh's got his marching orders now.
The longer we let this go, the worse it's going to get. You know, the sooner that this message gets to these people, so that the thing doesn't grow from a little ball to a great big ball, which almost becomes manageable.
One thing we are trying to do right now, and I say trying to do because I haven't got anything specific on it yet, but through the Federation of Canadian Municipalities, we are trying to get the message out to their members.
It's too slow, you know? When are they going to meet? When are they going to get together?
Again, we did, and I don't know what happened in this region, but we did send.
Well, I think it's up to you to correct what you didn't do.
Well.
Or what the regions did.
Okay, that's a good point. That's a good point. I mean, I agree.
Just instruct your regions to send a letter to all the municipalities in your jurisdiction advising them that it's your legal opinion that you're responsible for the highest record.
Not only municipalities, but the province is divided into 29 regional districts. And the regional districts run the building inspections and services for the unorganized areas. So just to say you send it to municipalities is not good enough. You've got to cover everybody. You know,
I can't argue with that.
Monday, right? So far, what I see here is, if I phone up Stan with a problem, he can't give me an answer because you people back there in the promised land will not give him any backup. You know, so we're not getting anywhere.
Well, I guess it depends what you mean by backup, and I'm
Well, we got problems with antennas and with municipalities, and we'd say, but if we phone up our DLC here in the Lower Mainland, they can't do anything because Ottawa not giving them enough backup to give any jurisdictions or any instructions.
Okay, and I guess my question is, what do you mean by backup other than advising the municipalities of our position?
That's what we mean. You take my place. I got a 30-foot tower. I want to go up 10 feet. Municipality says no, but 20 feet away I got a 60-foot fir tree. It doesn't make sense to me.
Yeah, I agree with you. I agree.
Comment on that situation, if you can answer his question. The local Department of Communications office that I dealt with, we sent letters about, I sent letters to them, and we talked about it quite a bit. After the city sent me the letter saying take the tower down, the person that I dealt with at the Department of Communications ended up sending a letter to the planning officer at the city of Vancouver, restating and re-emphasizing the fact that the Department of Communications has authority over antennas, and mentioned a few of the things out of the CDC document, and basically reiterated what the responsibility of the city was and what the responsibility of the DOC was. So I would say that the local office did react, I think, in a pretty favorable way. And as it turned out, if they'd gone away and forgotten about me, that it worked. But they could have gotten a lot feistier, I guess, if they wanted to. So to come to the defense of the DOC, the local office absolutely came to my defense in the final stages of it.
You're talking about Miss Angela's letter, I guess.
Sorry?
You're talking about Angela's letter.
Angela,
I guess to just to add another bit to this, and I don't have to tell you this, I'm sure that we're living in fairly dangerous times here, and I don't know what policies are going to roll out in the future, but it's from a political perspective or a public viewpoint perspective, things aren't as they were 10, 15, 20 years ago, and the environment and structures and the whole bit has got a totally different profile than it did in times gone by. I know I've heard people say that perhaps what we should be doing is coming up with some kind of what is a basic antenna structure, or what is, you know, what would be considered favorable, what wouldn't be considered favorable. And this, you could do this. You could come up with a sort of a guideline for what is a typical antenna installation. However, that is very much a two-edged sword that you're going down the path with. Because if you're going to do that, you want to make sure that you're going to come up with something typical that is favorable to you, because it may not end out that way.
I have another
Sure.
interesting point. If the DOC is saying that they cannot and will not control the height of an antenna, are they not contributing to their own expenditures in the area of interference? Because if you can't get your antenna clear, aren't you possibly causing a great deal of interference? And doesn't that cost the DOC a lot of money in time spent on the phones with persons complaining, or amateurs talking to the Department of Communications and going through all the intermediate steps? Wouldn't it be a lot better to spend the monies you have by putting a bit, writing those letters that were mentioned earlier, and thereby lessening the time you have to spend with persons asking for inspections of stations when someone's small little cheaply made phone gets RF interference? It's not completely the same thing. But if you are saying that an amateur cannot use proper antenna installation as far as height or clearance to make sure he does not bother his neighbors, then aren't you contributing and wasting your monetary resources Canada-wide?
Well, I guess we're not saying that an amateur can't use proper height and whatever in his installation.
You're not going to stick up with them if they do, though.
Well,
Yeah, Tom, I've got a thought here, too. You've got an amateur station, any amateur station, and let's say I get a turn down from the municipality. I can't put up a proper antenna. So I go around the yard and I put up a length of wire that happens to end up parallel with the television cable lines and phone lines and everything else, and it's a few feet away because it's down on the ground legally where it's supposed to be, and the kids can get wound up in it and get shocked and everything because it's within the limits, only 1.8 or 1.9 meters off the ground. And I throw the power to it and I wipe out the TVs in the neighborhood. Are you likely to tell the municipality, gee, this guy would do a lot better if he put up a proper antenna, or are you just going to crap on me and you know?
well, if it's a case of an interference investigation and you are not, and the antenna is a problem, yes, we're going to tell you to put up a proper antenna. Exactly what that means as far as okay, I guess have we, is there any more questions before we move on?
I put a long wire antenna with those 2x4s from my sub deck to the carport.
Oh, what is an animal structure? There it is. We got to have that.
Yeah, for receiving only.
Okay, what are you gonna do for it? What are you gonna go back there to my working lad there?
Well, there's
so far you're a candidate for a job.
yeah. Well, there's one major thing we have to do, and that's to ensure that our CPC makes it clear what I've just spoken about today as far as our policy goes. That's one thing. There's another thing we have to do, and that is to try to explain to the municipalities better than we've done in the past, and not just the municipalities, but others such as yourselves, exactly what our policy is.
when can we expect this?
When can we, well, the, yeah. Okay, well, sure, I'll go along with that. There's one other,
I'd just like to get it clear. Are you saying that you will write have your various departments and areas write to all the municipalities and regional areas indicating the type of bylaws associated with antenna structures that are ultra virus? Will you do that?
well, it's not the type of antenna structures, it's the, it's the whole proposal. The municipalities, as far as we are concerned, do not have jurisdiction.
Okay, maybe I didn't word that quite right. What I'm trying to get at is, are you going to issue correspondence to the municipalities in the region defining the federal position with respect to this type of legislation?
Certainly, certainly.
Thank you.
How soon?
We have, and I mean, in our defense, it's not that we haven't done this in the past. Maybe we haven't done it well enough or whatever, but we have done this in the past.
To who?
To the municipalities.
I
Well, okay.
Show me an example. Give me copies of letters and correspondence like I've asked for before.
Okay.
Well, I think the problem is, they send this stuff out and it's filed and people change jobs and whatever.
No, just to straighten the record, the district manager in Vancouver did send out letters, which were accompanying the original CPC to the municipalities in the Vancouver district. I don't know about the rest of it. So there were letters going out, but I don't think people understood the implication of it.
No, in the case of the Corporate Criminal Council, they were unaware of it. However, the alderman did say that it might have gone to engineering and into the file. In the case of the regional district, Bill Brown states emphatically he never received anything. Period.
Further to that, how do you get the floor to put a question across? I have a question I'd like to ask. You're talking about documentation and letters that have been sent to the municipalities. Is there any document available explaining the DOC's position that the hands that are having trouble with the municipalities can obtain and show to them and say, this is what my guidelines are, what are you doing? Do you have a document available that they can request?
Well, they should, the CPC that we issued last year this should be clear in that document.
Are copies of that available to any of the hands?
Certainly.
Yeah, they are.
Certainly. Certainly.
Why don't you send it out to the elections? What do you do now?
I think you might want to change the subject.
Okay.
Gentlemen, would it be reasonable, I think we've talked this one out. I might just add to our guests that we are working on a communication package. The Canadian Radio Relay League and the Canadian Amateur Radio Federation are working right now on creating a videotape and brochures and documentation. It's not just the DOC that have to do something about this. As Tom mentioned a moment ago, it's a big new world out there. And we've got to do our own PR work. We've got to get busy. We've got to sell ourselves to municipality. We're not communicating well. So what we're going to hopefully be able to give to you in a few months down the road is a video which you could take to your local municipality or municipal officers or municipal administrators and brochures and the club executive or whoever feels that would be appropriate to go there and talk to them and tell them what ham radio is all about and how you enhance the community and why these antennas really aren't as bad as it seems, okay? That you do a good job. So we have to do our bit as well. This is another point that we must never overlook. And it may be that it's fairly obvious there's going to be a test case done one of these days. Somebody's going to be sued or somebody's going to get himself into serious trouble like Jack Ravenscroft did in the Ottawa area here a few years ago. And it may be that what we may have to do is start a fund up to cover the legal expenses and the legal costs of defending amateur radio interests at that time. So these are the kind of things you're going to have to look forward to. With your leave, I'd like to, when we have a moment, I'd like to allow the gentleman to go on to another area of discussion, if you like, rather than antennas.
Just one comment along, if an amateur, whatever municipality passes a bylaw that gives these restrictions, as a citizen, we send that bylaw to you
on to our complaint and write a letter to that municipality?
Certainly, we would advise, if we were, you know, that kind of situation developed, we would advise the municipality, sure.
Yeah, well, that seems to me a practical approach
Of course
that,
it is.
that we can take, is to monitor the bylaws around us and
We are doing that.
register a formal complaint.
We are collecting bylaws which we consider ultra vires from across the country. You'll probably notice there's a chap in Alberta that you send the copies of the bylaws to. And we will be sending these, or delivering them personally to the minister if we get the opportunity, or if not, we will be officially sending them to the minister so that he knows where the municipalities are that are challenging federal jurisdiction.
Okay, good. Thank you. Now I'll go on to one of these other two gentlemen. Oh, no.
I'd like to bring up a problem that's occurring in this area with regards to a station in South Vancouver, actually South Burnaby. This station is operated by American operators who moved into Canada. They weren't allowed to broadcast by machine, Morse code 24 hours a day in the United States, so they decided to move across the border, and they're doing this in Canada, and they're occupying a chunk of 20 meters, 24 hours a day, and I can tell you from things that I've heard from my friends that this is a non-operated, it's a non-manned station, sending by computer code 24 hours a day. These people, there are hams who live in the vicinity who cannot operate on 20 meters as a result of this high-powered code being sent all day long. But our club has had some communication with these people, and they have agreed at certain times they might shut down. What we would like to do is have them shut down, period. I don't think that American operators should have a right to come into Canada and operate these stations under these conditions and destroy the hobby and the fun of amateurs who live in that area. And I know that the DOC has had some contact with these people. I would like to have a report on what they're doing about it and whether, I seem to get the feeling that they feel that they don't have the legal right to tell these people to shut down and leave. And I would like to see the Minister of Communications take this action into hand in Ottawa and make a proper decision.
Yeah, I guess I would ask, are you people aware of this at all, or I
Excuse
believe.
me, I personally have copied this book with the computer. I've sent 24 hours with it, bundled all up with a covering letter, sent it to Ottawa, and was told basically that he had as much right to operate in this country as I do. And that's it. What's being said on there is Hare Krishna religious tracts.
That's right.
Do we, like...
I believe the letter came from the minister himself.
Yes, I sent it to Ottawa.
Yeah, and you get the reply from a minister.
You know
that is the highest we can go.
Okay, I'm not aware of the specifics of this at all.
But this man, it's driven by an IBM 286
No,
AT.
the minister maintained that this gentleman did not violate any Canadian law. If you can point out to the minister under what section of the radio regulation he's in violation of.
It's a broadcast. We're not allowed to broadcast.
But our minister took the attitude that it's not broadcast.
Well, it's a funny attitude because it's a broadcast. It goes on continuously and he doesn't communicate with anybody. There's not two-way communication. It's definitely
communication number for
I think Jim Cummings been investigated. He drafted the letter.
Is this something that's still ongoing?
Yes.
And what?
14.53 anytime there.
Okay, and what did we? How long would we reply to this? Do you have any idea?
At least twice from the minister's level, I believe Jim had something to do with it.
Okay. Okay. Well, the best I can do is look into it because it's news to me.
Go back and ask Jim.
This particular station is operated by a man on a visitor's visa. Quite often he's not even in the country. He's back down in the States in a
station is still operating 23, 24 hours a day.
Jim know about it.
Is that legal for him to be in another country and still transmit in this country? For us to try it down there, we should be shut down.
It's not even legal for us to send like that here. We have to man the station. We have to man it.
Okay, again, yeah, I take it from the letter that was sent out that we said this guy wasn't breaking any regulations or whatever, or this kind of thing?
I believe one of the inspectors from Vancouver office pointed out.
Okay. Okay, well, anyway,
You can check in.
I'll find out what the story is on this, because it seems to me rather strange that we would send out a letter saying that he hadn't, this individual wasn't breaking any of our regulations.
That's correct, sir.
If
I'll provide you a copy of the one I received.
okay, I don't know what else to tell you at this time, but anyway, we can find out what the story was on it.
And get back to hobby.
Yeah, I guess get back to Hoppy. Is that fair enough? Okay. Get back to you on this, Hoppy?
Yes, sir.
Okay.
Jim know all about it.
Okay.
E7 is the American call sign /E7.
Okay.
KY0G, I believe.
Yeah.
That's correct.
Okay, well, anyway, I could find out the particulars of what we've got on, or what we sent out, why we sent out it, and I can get back to Hoppy.
What else you got here?
Okay, well, now we'll move on to another subject. There's a real criminal here tonight, Hugh Clark, who has been involved in our delegated examiners and our restructuring of the amateur service for quite some time, and I guess I'd like to get him to talk to you for a while on what we have planned, and I stress the word planned, as far as further delegation of activities in the amateur service, and to get your comments on the way things are going. So having said that, Hugh.
Pleasure to have been with the group who have instigated this new amateur operator certificate arrangement, which seems to be working reasonably well. This afternoon I checked with the office and they tell me that we are in excess of 36,500 licenses now in Canada. The concept of the basic advanced 5 words a minute, 12 word a minute arrangement came about after consultation. People claim that we don't consult. We went backwards and forwards a dozen times on this thing. And finally we came up with something which seems to work. The whole idea has been very helpful, and it seems to have worked. There's a lot of people getting into the thing. There's a whole new feeling about amateur radio on both coasts and in the center. It's a different ball game out there, ladies and gentlemen, than it was 3 or 4 years ago. And although we're developing growing pains now, there are problems which are beginning to show up, and there will be. But we're living in times of change. We're all well aware of that. One thing which might interest you, especially for the delegated examiners, that is, who are going to get the examinations, we'll be coming out with a new arrangement for examinations. What we're planning on doing is providing a computer program which will prepare an examination, set the examination up, and give you an answer sheet, all menu driven. So, as a delegated examiner, you're there giving the examination. You say, all right, if somebody comes in and wants an examination, fine, I want a basic examination. You press B. The menu comes up and says, fine, we're ready. It goes ahead, selects the questions, sets the whole thing up, and gives you an answer sheet as well. All in hard copy, prints it out, and you give it to the person to write. Therefore, it's going to be pretty hard to cheat. Everybody says, well, there's all kinds of cheating going along. They've memorized that 100 dots on those 4 or 5 question and answer. I think it would be easier to memorize the 700 or 800 questions in the bank, but suffice. This way, each exam will be different. One thing which we are also doing with the amateur delegation, which Hoppy is aware of, and we have talked about it, is this idea of offering to the new amateur group, when it comes into being, some further delegation. For example, we could offer the emission of call signs, special call signs, for example. The 100th anniversary of the founding of the CPR or something, a little late for that, 150 now, I guess, getting on toward it anyway, of the CPR crossing the mountains or whatever, and hence, perhaps, some sort of a special call sign. Possibly the issuance of a temporary authority. Possibly the issuance of the complete amateur examination. If we go through this amateur examination, then it's very easy to give you the program and say, fine. The big question that's going to be asked by a lot of people is, and I'm not in a position to be able to answer it, how is the finances going to be shared? If we're going to give something, we expect people to be able to take it. This we will work out over a period of time, ladies and gentlemen. We're not going to try and get you to do something for nothing. We're very, very happy with the delegated examiners that we have out there. People who are doing it are to be congratulated by not only the department, but by the amateurs. They're taking their time, and they're doing, well, quite honestly, one hell of a job. And I want to personally thank each and all of them myself tonight. The whole thing about delegation is now in the hands of Montreal. They're finishing, the Montreal Regional Office is finishing up a study which was conducted. Like everything else, there's a lack of money. We did manage one in Montreal, one in Toronto, and I believe one in Winnipeg to sit down and talk to people. It would have cost us another, I think, $10,000 if we went to the east and to the west, and they decided that we would get enough information out of the 3 areas to be able to determine where we sat with it. It appears that most people accept the idea that we can delegate stuff out to the amateurs, but there's a group of people also, especially those living fairly close to where we have district offices, that, whoa, here's the department trying to shove it off to someone else again, to get out of spending this and doing that. It's not our intent. Our intent is to give you, or at least to offer to you, this opportunity. Maybe you can serve yourselves better than we can in certain areas. And that is what we're going to look into and discuss with the new organization, or at least as the format goes along. Now, ladies and gentlemen, I can talk to you about certificates and amateur delegation and things like that. I don't mind at all. But for me, I'd rather stick to that rather than get into something else. If there's any questions, I'll be pleased to answer what I can. Go ahead.
I hate to be standing up all the time, but I happen to be one of those examiners. I guess I've done quite a few. I've noticed a few problems that I would like to see corrected.
Sure. Right.
First of all, I think we could cut down on the paper it takes by separating the English from the French. And I'm a French Canadian, so if we separated and had a disc for French examinations and a disc for English examinations, it would be better.
It might be in some ways, but not to.
No, but just
I realize the paper problem, but there are many people who claim that they want both. Especially, well, all right, out here you've got one problem. Yeah. In the east we have another problem. In Manitoba we have another problem.
Well, I'm saying you can have both, but you can ask the person, do you want to rate the examination in French or English?
Okay.
And then simply produce that examination. The other thing that's worked very effectively from that for me, and I happen to be a school teacher too, so I mark lots of exams, and one of the tricks with multiple choice is to have an overlay, like we have on an overhead screen, an overlay. I produced an overlay, and I can mark that examination in about 3 or 4 minutes.
Mm-hmm.
Okay? But that is not provided, if we change the exams, we now have to produce an overlay for that particular exam.
No, it'll be produced for you.
Okay?
That'll be part of the exam program. It'll be a part of the exam program. You'll get your overlay.
I also ran into an interesting problem last week. I examined a fellow at the club the other day, and standard procedure, of course, is that do not try, it's cardinal sin to contact the DOC before 2 weeks has elapsed. And of course, the fellow, even though I told him, he still tried it after about 2 days. He went out to Surrey. By the way, that examination, when I marked it, I put it in an envelope with a stamp on it, and I looked up the address in the phone book, and I got the envelope back about a week later. It says that this address did not exist. So now I had to remail it. I've now remailed it to Vancouver, and I said, you send it to Surrey, see if you can find them. Cannot send a letter, the post office can't send a letter to the Department of Communications, there's something wrong. And in the instruction sheet I have, which authorizes me as an examiner, it does not give me the address of the Vancouver office. It does not give me the address of the Surrey office, the official address. It doesn't give me the names of who to talk to or anything like that. I just have to go by what I've got. But there's a few problems, and I think they could be addressed if they simply, once in a while, simply ask the examiners, have you got any suggestions on how to make this thing better? We could write them a note. I want to add just one more point, and this is for the people who get their first examination and they pass the 5 words a minute. They're allowed to use 80 meters and 160 meters. I think we should open up 10 meters to those people. I have a little bit of a beef, and this they get the code and they don't use it. So they get on 80 meters or 160, and they get on phone right away. They never use their code and upgrade. But I think that they should have some incentive to get up on 10 meters because it can be a lot of fun and use it like the American officers do. Thanks very much.
Welcome. Please.
Yeah, I just was going to complete a little bit what Lou was saying. DSLMR actually. Why don't these people are given eventually 10 meters, only CW, 80 meters CW, 40 meters CW, 20 meters CW, and chew a little bit of things there, and then get on single sideband. We would avoid lots and lots of complications with this.
Well, first of all, ladies and gentlemen, something I didn't go into. As some of you are aware, this global maritime distress and safety system goes into service in 1999. And what that is a restructuring completely of all the maritime stuff. Now, you say, well, what's that got to do with amateur radio? Something very simple, ladies and gentlemen. Up until this particular time, the bulk, that is up till about 10 years ago, the bulk of communications by maritime out in the main, in the overseas operation was done on Morse telegraphy. That's coming to an end. With GMDSS being officially instigated, I think the date is February '99. Everything is supposed to be in place. There will be no further requirement for Morse telegraphy. This means that in all probability, there will be no further requirement for Morse telegraphy for amateurs neither. And I can see around here, oh my Lord, what is going to happen? The world will come to an end. Perhaps it will. But if it waits till the end of the century, I probably won't be here to see it anymore. What I'd like to just simply say to you in way of explanation. With this new system that we have in place, you have your 5 words a minute, and you have your 12 words a minute. Those can be easily taken out if we want, and we'll carry it on as is. There will then be no code requirement whatsoever. And I suspect internationally it will disappear in the next World Amateur Radio Conference, or I'm sorry, World Administrative Radio Conference. In fact, there was some talk that Canada might do it this time. the last meeting, but this didn't come up. We didn't talk about amateur so much. I find it very difficult to accept the lack of morse. I'm a commercial operator. I operated in many places throughout Eastern Canada and at sea, and I have problems with that. But I also know that we're living in changing times. We have many, many, many facilities in this day and age which are much, much better as far as getting information across. They may not be quite as narrow in frequency, but they certainly will get the information across, and they do it much more quickly. That means a saving in time, which means a saving in spectrum. So for us, in long term, Morse telegraphy is now, after 100 years, served its time quite nicely.
If you're concerned about saving the spectrum, then getting rid of Morse code will just waste the amateur bands, because everybody will go on. Well, next thing we'll hear is breaker, breaker on our signal.
Is that happening now?
Yeah, it's starting to.
Yes. To a degree, yeah. We've increased our, close to what, 25, no, over, that's going to be 30%. We've increased increased our amateur population by over 30%, I would think now. Yeah, we're going to get some of that. We're going to get some changes. But that's one of the reasons that we've done this. Now, we have you people all out there that know the right way to do it. I'm sure that you're going to tell them, and in no uncertain terms.
That's all the more reason we need a good guideline on antennas. You're going to have a lot more people putting up more antennas, so we need good laws.
Perhaps. We'll see. Go ahead, please.
Hi, my name is Rick Streifel.
Right.
I've heard rumors afoot that there's going to be a change in the way that call signs are issued and who they're issued by. Is there any truth to that rumor at all?
No, you'll have to be a little more explicit. I don't know of anything, quite honestly.
There's been a couple of rumors that have floated around. One was that the DOC had intended to turn the issuing of licenses over to the RAC whenever it becomes formed. And another one that I heard was that they were going to issue a block of calls to an examiner. You go in, you do your exam, you pass. You take his check, give him a license, and away you go.
Those both may be possibilities, but they'd be something that we'll be talking about with RAC or within an organization. They aren't, they're pie in the sky at the moment, okay? There's no intention by us for doing it, at least for the moment. Yes, please.
North V7FKN. Concerning call signs, we are now starting to see call signs issued to people who are resident in this province and holding call signs, say, from Ontario or the Maritimes. And I can see it if the person is out here on a temporary basis, a year or so, but for a permanent resident, I would like to see them have to hold the call sign of the area in which they reside. We see in the U.S. the mess that it's in by portability of call signs. And our club wrote to the regional office, and we were informed it was a monetary thing. There weren't many people doing it, which is probably true. But now that you're rounding out the increase in license fees, you're picking up about an extra $16,000 this year. Maybe you could put some of that to the problem.
That's going to be just about pay for the mail out, actually.
We'll have to deal with the post office on that.
Thank you for bringing that up. That is a point that we have discussed in times past, but I think the answer is what you said. There's only a few. And I understand where you're coming from as far as when you compare it to what the Americans have now. You're working a W-8 and he's in the Virgin Islands or something, and all of a sudden you don't know who you're talking to anymore. But call signs are issued to an individual. Commercially, you issue a call sign from a block, which is given anywhere. You could have a VCW 123 in the Maritimes, and you could have a VCW 952 in British Columbia. It's given to the license is issued to an individual. We have for years gone with this arrangement that V1 the Maritimes, well, now that's changed. V2 is Quebec, and so on and so forth. This may change too. This is something else that may happen. But for the moment, we're looking at it in the sense that for the moment we're not really going to address the matter, although we'll look at that $16,000 and see what it amounts to.
I think the
just
US
a moment.
is probably the only jurisdiction that has gone the way they have. Is that not correct?
I'm sorry?
The U.S. is the only jurisdiction that has gone with the issuing of the call signs without regard to region. The rest of the world, it's nice to know you're talking to a G4, and he is a G4.
I know. But the Germans, for example, had you've got DL2s and DL4s and DL6s. There was no particular arrangement as to a particular area. The Brits for years issued the G4, the G3s, and then the G4 blocks. There was no particular area that these things came from. Now here in Canada, we've done this for the very simple reason it was very easy to keep track of them. You have great blocks of land, which are 10 times the size of UK, sort of thing. So it really didn't, they were all Gs, they were all GMs or GWs, or whatever the case may be. We'll certainly take it under advisement, and it's something that tends to bother me personally, but it's not something that we're going to probably change right off the bat, as long as we have a mailing address. Okay. Now, was somebody back here that had a question? Yes, go ahead.
I just wanted to ask a general question of whether amateur radio has much of a profile within the ministry, and if there is a way in your mind that the profile could be raised.
Well, and I'll get to you in just a second, okay? I'll put it this way. The minister, of course, I'm sure some of you, I don't know how good the reception was out here. We crossed our fingers a lot on that circuit and hoped when he did come on the air back in the end of June. He was very, very favorably impressed with the system and how well it worked. He was, I can't say how much. We got some very, very glowing reports back from the ministerial level on that exercise. And when something else came along a few weeks ago, the amateurs, that had nothing to do directly with the amateurs, but might impact on them indirectly, the minister was very particular in asking these same people, that is the amateurs with whom he had had contact there, about this particular thing. Did we feel that this would impact badly, this particular piece of legislation that they were looking at, that this would impact on the amateurs? Now, whoa, when he's going to take time to ask this in the middle of this whole thing, I think you've got a pretty high profile at the federal level.
How do we keep it?
One could make a political comment, but one won't. Yes, go ahead.
Yes, my name is Bob Burton, I'm one of your delegated examiners. And first to comment, my dealings with the DOC at the Langley office have been very favorable in this whole process. I went for an interview that lasted about 2 hours when I applied for this DE status. I was given all of the material, all of the addresses. I do have a postal address, sir, if you need it. So, you know, I'm really satisfied with that aspect. I do have one small concern, however. Time back, a couple months ago, probably sometime in the fall, there's a letter that came out saying that there's a few little changes to how we fill out the application, and now that we require ID and a few extra little administrative things. But one of the things that was in that letter was the fact that a delegated examiner who is involved also as an instructor, which I am currently doing out in Abbotsford, will not be permitted to administer the exams in the class that he's running. I find it incredible that the DE's integrity would be questioned if he's volunteering all this time to teach a course, and then be told that, well, we don't really trust you to administer the exams to your own people, but you might fudge the results. I don't think that's on. That was the only piece of correspondence that
yeah, but not everybody volunteers their time to teach the course.
It's a concern which I would certainly want to leave with your own region and your own district office. And I think that's where it should remain under those circumstances. But I want to thank you particularly for bringing it to the attention, because I'm sure if it's a problem for you, it's going to be a problem for others.
If you're a professional instructor, I believe you can administer your examination.
I'm sorry?
I say if you're a professional instructor, I believe you can administer your own examinations. There's something in the letter that I remember.
Okay, that's quite possible. Again,
Let me get to the when you come back. You came from Vancouver. You come from your office. In Vancouver.
well, I would think so, but again, I may be delving in dangerous waters here, and that my friends probably will make this arrangement. As far as we're concerned, if you're a delegated examiner, you're a delegated examiner, whether or not you've given the instruction. But as I said, because of certain things, maybe there are other arrangements necessary, and that I would let Richard answer if I may.
Unfortunately, the instigator is not available to defend himself. It came from Mr. Thompson, I believe. It's not true, Stan?
Yeah, that's what the package originally.
We have to check with Mr. Thompson to find out the full story on this. I'll check on it personally for you.
The letter states, I'm a delegated examiner as well. The letter does state that if you're in an outlying area and there's no other examiners available, that you can examine your own classes under those circumstances. But I think what they're trying to get at is in a municipal area like Vancouver, Lower Mainland, there's lots of us around. One guy teaches, the other guy examines.
Yeah.
It would be nice if you're going to teach the class, to be able to examine the class. Because there are your students you want to see exactly right now.
Okay, I do all the exams for Albert that teaches at Con West, and he kind of likes having me come in because it gives the exam a little more importance to the students. It's not a matter of going through the entire class and at the end Albert gives you your piece of paper that says congratulations, you're finished. Now they've got someone that they've got to come in and prove.
I do the same thing for the Burnaby Radio Star. I quit teaching because I couldn't examine my own students. Also, there was a statement I got the last letter that you have to inform your student or the person you're examining that he may be re-examined at the discretion of the department. I would like to know what reference that has to us.
Well, we've always retained the right to re-examine. Brian, just a second and I'll get to you here. Sit down, take your load off your feet. I'm sitting. We've always retained the right to do a re-examination, even of our own inspectors. We've always done that.
Yes, but this was not brought around in the very beginning. It was only brought to light on account of a certain party that was supposed to have gotten its license by hook or crook off of one of the examiners, which wasn't so. Now all of a sudden we get this, the examiners get this thing stating, now you have to tell your students such.
Once bitten, twice shy. These are things that you can work out, though, with your own people. I'm sure they've already been done. But I told you at the outset of this thing, there's growing pains. There always are. We know that there's going to be changes that'll have to be made to things as we go along.
Are you going to deliberately, like, seeing as we have a piece of the action now, and we like it that way, at least I do.
Yes, obviously.
We would like a block of calls that if we're marking the guy and he's passed, he can send his own money into Ottawa for his license and everything else, the fee for it and everything else, but we'd like to get this call right there on the spot. Our signature on it is good enough. I mean, what does the department do? All they do is sign their name and send it in, and that's it. The guy's got to wait. And,
the way I do an exam now is I have all the licensing documentation with me, all the application forms for the station license, everything. I tell them if you want a specific call, in 2 weeks go down to the DOC and fight it out with them. If you want to take potluck, fill out this form, and I'll mail your check in with it along with your exam results. You'll get it in the mail. What's the difference if I've got a list of call signs and I print his name on the bottom?
Well, this is something we can certainly take under consideration. This was one of the things that I said at the outset, that we might offer to the delegated examiners when it came under rec. But possibly we can do this before. We'll take it. I've made a note of it, and we'll see what we can do. Please.
I'd like to say that I think it's a great system because it's quite apparent to me that some of the people who are taking the exams feel more comfortable. The setting that it's always been in my case, it's always been on an individual basis, except one time when I did about half a dozen in the school, and they all fight incidentally. Otherwise, it's a comfortable environment, and I think for people who are nervous, it's a great idea. One thing bothers me a little bit. Not too long ago, I administered a protest to one of our club members, and during the 4 or 5 days prior to that, I've been giving him some intensive code practice. Should I disclose his name and have him retested, or what? I'm just making fully ready.
As a delegated examiner, do you feel comfortable with his having passed
The
it?
thing is, I'm only an amateur.
I don't hold a commercial certificate any longer either. I'm just an amateur, you know.
It's just a comment on what was raised before. I
Yeah.
think it really is
But if
totally irrelevant.
you feel comfortable that he, as a delegated examiner, if you feel comfortable that he's passed the examination, I'm not going to question you.
Copies the DOC.
That's all that's necessary, as far as I'm concerned. But as I said, you have your regional and your district people here to talk to. I see it's after 9, and I don't want to keep this too much longer. Yes, but I'll take this last one. Go ahead.
Thank you. Yeah, I've been waiting for you to come for this thing. This RIC 25, there's a couple of things in here, at least to me, that aren't that clear. I've been in Hamilton just under a year, and hams who have been at it a lot longer than I have taken both sides of my question.
Go ahead.
It's, the part about supervision.
Yes.
I have a basic certificate and an advanced certificate, but no code. And
Okay.
I announced to my club on the radio one day, bought some HF gear, and now if one of you guys would like to come over to my place and let me operate under your supervision, I would appreciate it, and that would help me learn operating procedures and everything else. They're great, this, that, and the other thing, everybody come in. But they were on both sides of the question. Some supporting me that I can do this, others say you can't do that. And yet in here under supervision, number 43, it says no licensee of an amateur station shall permit a person who does not hold a certificate or license listed in section 42 to operate that station except under the supervision and in the presence of the holder of a certificate or license. And my logic tells me if they have the certificate, I should be allowed to operate that.
I think you have to go back an awful lot further than that. I think you have to go back. I think you have to go back to the Radio Communications Act, which is also marked in there, which says in effect, you shall not own, operate, or have in your possession. Bill, if you wait afterwards, I'll be quite pleased to show it to you, okay? I assure you it's there.
Hey, ladies and gentlemen, I think there's another very important item on that agenda that ought to be thoroughly discussed tonight, and it's really threatening amateur radio, and that's electromagnetic compatibility matter. We talk about telephones, we talk about VCRs, we talk about TVs, and all of these various home entertainment projects, security radio systems. The susceptibility of these products to radio frequency energy is causing a lot of people a lot of problems. And one of the problems we have in this country is we do not have standards. And I'm not so sure we're going to get standards. That is, the people who produce the products ought to be asked to make or somehow ensure that they produce products which have some minimal protection against susceptibility. So I'd like you to ask some of these gentlemen tonight what they might be willing to do about that, if you're already having trouble with that.
What might you be willing to do about that?
Well, I would have to agree with Hoppy. We don't have standards, and I'm not so sure we're going to get them. We may get them. I don't know. The latest proposal that I know of is we are looking at going to basically a mandatory, voluntary, tiered approach. That's an interesting concept. What we're saying is that in cases there would be mandatory standards that would be required for cases where you have, I guess what could be referred to as safety equipment or emergency equipment. What I'm thinking of is like heart monitors in the hospital. They would be required to meet a mandatory standard for RSE, or radio sensitive equipment as we call it. It would also be mandatory that labeling be applied to all these radio or these electronic devices as to what level of shielding or RSE protection, or whatever you want to call it, or RF susceptibility that they meet. Now what this would mean is we would have essentially 2 or 3 standards, and I think 3 was basically what they were last looking at, A, B, and C, or whatever you would want to call them. And the manufacturers would have to, it would be mandatory that they stuck on their product what susceptibility standard this product meant as far as RF susceptibility goes. Again, this is a proposal. I don't know whether it's going to see the light of day, what is going to happen. I know it's a serious proposal at this point of view. It's got its proponents, and of course it's got its detractors. But that seems to be the direction that we're heading as far as standards go.
Do we know who we need to convince? Do we know who we need to talk to about?
Well, you like all things, by lobbying our department doesn't hurt. You have to understand there's of course a lot of different sides to this. The manufacturers to a great extent are not thrilled about this idea. We had we started several years back what we referred to as our 3 R's policy, which was repair, replace, and what was the third R? Return, I guess. This was a voluntary thing. We tried to go through the various auspices of the RABC to publicize it and other organizations. It never really has panned out. The manufacturers really didn't show any particular interest in it. With everything you do, it's the old story of if you're going to add cost to a product, and it may not even be a significant cost, but if the government is going to legislate something to add cost to a product, then you've got the other side of the coin of people who don't believe that this is required or necessary. So yeah, lobbying is the word, and people such as us, I guess our department is who you should be focusing on.
Is there any way of getting that put into CSA codes?
Well, see, CSA is not a mandatory standard. CSA is it's a standard essentially because there's a lack of standards for certain things. But again, it's really a voluntary standard. So I don't see that route applying.
Well, I disagree with you on that route. I sit on CSA committees, standards committees, and the particular standards that I deal with are mandated by legislation. For example, the National Energy Board Act mandates certain CSA standards as law, all of the provincial.
So you're saying, for example, our department, and you're quite correct, we could, should we deem it reasonable, we could mandate a standard.
That is correct.
Yeah. Okay, that's a good point.
Many of the CSA standards are mandated by provincial or federal legislation.
You'd be in a better position, I guess, to answer this than I would, but it's my limited experience in that mandating CSA standards has not been, it's not been a big thing up to this point. It seems that the provincial and federal governments have not gone that way in a lot of cases. Is that a fair comment?
All of the electric commissions mandated by every provincial Department of Labor. And you can't install any wiring devices or electrical equipment in any province that doesn't carry a CSA label.
Okay, well, I'm wrong. There's a good example. Okay, that's another route you could go, definitely, definitely.
How would you go about that? How would you get, well, maybe you can answer. How do we get into this to get to put the odd little piece of equipment in there? There's none. Well, bug-proof from my city.
Okay, from our perspective, and I can't speak for CSA, but from our perspective, if we are going to do up regulations, and we are looking at this, as I say, right now with what we call radio-sensitive equipment, before we can propose regulations to the Privy Council office, we have to go through a RIAS, which is what they call a Regulatory Impact Analysis Statement. What this means is under, me too. What it means in plain language is that you have to prove to the Privy Council office that what you're doing makes sense, there's a requirement for it, it's not going to unduly affect Canadian industry, et cetera, that kind of thing. In other words, it's to ensure that regulations aren't made by government departments for the sake of regulation making or because it looks like a good idea to a select few, this type of deal. So essentially, before you are going to get those kind of regulations you're talking about through, you would have to have consulted widely with the manufacturing, with industry in general, with the radio users, and the whole enchilada, really. But it's a doable process. It's a matter of the political will being there to go that way.
All that I know is the girl next door gets uptight when she got out of romantic music, with her boyfriend alone, and all of a sudden she hears my voice come through her
I can have a certain amount of sympathy for her, you know.
Well, going one step further here in the practical sense of this thing, can we expect then that with this multi-tier standard to protect ourselves come Christmas, that we're just going to have to depend on our local ham merchants to stock RFI-proof telephones and small appliances so that we can just go and replace the stuff rather than take them to court and hire lawyers to fight them?
Well, you're jumping several steps ahead. I don't know what, I mean, when I say we're looking at this three-tiered standard thing, what does that actually mean from an operational perspective? Does that mean that we're going to walk into somebody's house at an interference investigation and say, you haven't got type A, you know, beat it sort of thing? I don't know. But that's, the idea is that you would have some standard and you would have, and we have to be very careful how we use these words, you would have equipment that would be more susceptible to interference from radio devices, non-radio equipment, than other equipment. And you would have the option of saying to someone, look, you bought the cheaper equipment, you're going to have to suffer with the problem.
Have you checked into other standards, like European standards and so on? Because the same tape recorders, the same video recorders and everything else is sold worldwide nowadays. And I'm sure that they have much better standards than we do in some countries.
Yeah, the Europeans are, and I don't know the state of what they're at, but they are going to, they have said they're going to a standard for RSE that is fairly stringent. And there's, depending on which side of the argument you listen to, there's a lot of people that are in favor and a lot of people that are against it. Another thing in this day of NAFTA and free trade and all this kind of thing is you have to take into consideration, I wouldn't say be careful, but you have to take into consideration that standards are not being produced as a means of protectionism for your industry or whatever you would want to call it. In other words, it's a case of where we sell it as we sell it politically as a standard that's required, but in a sense what it's doing is not allowing the trade of apparatus. So it's just another consideration that comes into it.
But if you don't follow the standards internationally a little bit, then all the junk will end up in Canada. We can't export anything to Europe.
Yeah, what you're talking about is harmonization of world standards, and I couldn't even hazard a guess as what's going to happen in that respect. We're having a hard enough time trying to harmonize standards with, I guess, our biggest trading partner, which is the United States right now. So I don't know. I can't answer the question for you from that.
Excuse me, but isn't the vast majority of this problem with the type of equipment that we are having experiencing problems with is this cheap crap coming out of Taiwan and Singapore and that part of the world anyway.
Well,
and I mean, when they meet little or no standards at all.
I don't know. I've been out of that for too long.
Surely we can control what we allow into the country. I'm offshore.
That's.
I would offer the opinion for myself is that yes, a higher percentage of that kind of equipment is more susceptible to RF, but not to say that that excludes the other equipment, because there is other stuff that.
Yeah, but you have to consider, if I may, you have to consider that the bulk of the problem is that piece of equipment is available for X. The other piece of equipment is available for X plus Y. If you go into the store, you're going to look at this thing, the same cabinet, the same dials, the same knobs, everything on it. You're going to buy X. Okay, but the average person, his lady friend.
I realize that, but I mean, can't we enforce some standards on what we allow importers to bring into this country? Are they completely open to bring anything they want in?
If you have a minimum standard, then everyone must comply, so they're all on even footing.
Yeah, and I mean that's the debate. Should we have a minimum standard as far as RSE goes? And that's the debate that's been going on for some time. And as far as I know, it's not solved. It's still a debate.
But what I don't understand is that the radio inspector has been so kind to come up. He's inspected your equipment and find it clean, pure, and 21. He says you'll have to work it out with your neighbor. In other words, he's not supporting you, is he?
Well, again, you got to get into the particulars, and you know, as just a blanket statement, we've heard it said many times that a kilowatt shouldn't be allowed in a residential neighborhood, regardless of what standard we would have for equipment. I mean, those are the two sides of the argument, and I don't have an answer for you, a clean answer for you. What we try to do is go in, make a determination, and get the problem solved.
Yeah, but when he comes in and says you're nice and clean and you're not, shouldn't be doing it, and then he just says, good day, and you say thank you, but won't you help me by going to the neighbor? No. That's your problem.
Well,
and some of these neighbors sure don't like you.
Okay, your turn.
Yeah, I can't speak for all the inspectors that work in this area, okay? I can only speak for the things that I've been involved with in the past, and I have a couple that are quite educational, to say the least. I don't have a problem with visiting the people that we're going to visit, okay? If you have a neighbor that's next door to you, I don't have the problem with walking over to the neighbor and talking to the neighbor and trying to work out some kind of solution between them and yourselves, explaining that, you know, you have a right to be on there too. But at the same time, they have a right to have the equipment that they have. And to find some kind of equitable thing we can balance between the two so that you can have your hobby and they can listen to what they want to listen to. I don't think it should be totally on the responsibility of the amateur to do the contact with your neighbor. Now, I know what has been said previously already is that we like you to take the first step. Okay, we like you to make that initial contact so that we don't come in and acting like policemen. Okay, now if that's not working, or it's not going to work in this situation, I don't have a problem with going in and talking to them and trying to, you know, find some middle ground for us all to work on.
But if they got a cheap piece of equipment that they've imported in from the Orient, and we have a piece of equipment that's worth $1,000 more than theirs,
Imported from the Orient. Sorry, Ernie, go ahead.
good stuff. And not complain about us buying junk.
Yeah, I think, you know, you got to keep in mind that the situation has not changed in the last 20 or 30 years or whatever, from the point of view of you are the amateur, you are the one that's operating in the neighborhood, and whether you're talking antenna or you're talking audio rectification or whatever, you are viewed by the neighborhood as being the guy that is doing, or the person that is doing something to disrupt what everybody else is doing in the neighborhood to their usual enjoyable pastimes or whatever. And that situation is always going to exist, where the onus is going to be on the amateurs to try to work out some of these problems.
Go ahead.
Radio interference by amateur radio or to amateur radio has been around for time immemorial. And most of us at one time or other have been involved in getting hold of the department and asking them for some assistance, only to be told that we do not have the resources. The question I put to you is, when will there be auxiliary inspectors that can deal with these kind of things and maybe go and approach these people that have that ordinance, that talk to them and what have you, and on the other hand, find people that make willful interference to amateur radio? Wouldn't that somewhere along the line relieve the strain on the department?
Yeah, it's a good suggestion, and I mean, it has a lot of merit, and it's been kicked around for a long time. Operationally, you're talking about something that is not that easy to implement. But if you look at the committees that exist right now, as far as the amateur EMC committees and what they do for RSE and this kind of thing, this is what we do to in a great number of cases, is we get a hold of a committee that the amateurs have set up, and they go and visit these people and try to work out the problems, which they do in a large number of the cases.
Well, what happens when you have a person that is illegal in operating or interfering or being interfered with, and you approach the department with documentation, tape recording, only to be told we do not have the time to go and handle this? Please go away.
Well, again, from audio rectification is not a pure interference matter from our point of view. I mean, we will go and investigate the amateur station because the onus is on us. We license the amateur and to ensure that they're operating properly. But the line that we give, generally, that we give to the complainant is that it's audio rectification, it's not radio-related interference, and it's to do with deficiencies in the equipment that's receiving radio.
I hear what you're saying. What I'm saying is, there have been times when the individual has been told that the department does not have the resources to respond to that. Wouldn't an auxiliary inspector be able to go and do this kind of thing?
You're talking about RFI, and he's talking about willful interference.
I'm talking about both.
You're talking about a non-paid helper?
Why not? You've got volunteer examiners.
Like it doesn't.
No volunteer policemen. No, I'm not talking about policemen. I'm talking about
Just before, gentlemen, I just wanted to remind you that these gentlemen that flown out from the east, I think yesterday, their biological clock is running about 12:30 right now. So I don't want to keep you too much longer, so one or two more questions.
Hoppy, I just had one thing I wanted to, before we close up. I had one thing that I wanted to say to everybody because it came up, I think it was a gentleman back here, he's a delegated examiner, and we have a problem in Surrey, and it's not really anything that we can have a lot of control over, but that's kind of the way it is. We have a site location, which a lot of you have visited, which is at 3884 192nd Street. The problem that we have is the building itself is in the middle of about 280 acres of farmland, which the government owns. They lease out to a local farmer. The problem comes is that, first of all, we cannot put a mailbox down at the end of the street because it's not secured. And heaven knows, as you're all going through right now, everybody's paying license fees, so we can't be guaranteed the money's going to be there. Surrey, what can you say? Now, the thing that we have to deal with is that the people who deliver the mail in rural routes will not drive the 500 feet up the driveway to give us our mail. So what happens is there's a confusion, and there's a problem in the telephone book that lists that address. So you look up the address and you find a postal code and you send it, and they won't deliver, and it comes back to you. So what we've had to kind of degrade ourselves to is the fact that we have a post office box in Langley. So every day of the week we have a courier go to the post office and pick up our mail for us and deliver it to us. So that's the problem with the mail, and we're living with it, and there's nothing we can do with it.
But he quits and I have a job.
Certainly.
The problem that we being asked to address here is, how do we tell whether a commercial VHF station working with VHF is working within its legal limits? Because where we live, we have a tremendous lot of intermod and just plain ordinary noise coming on the VHF thing. And we haven't been able to solve it, where, why, or any reason for it. It's actually coming over on one of the local repeaters. You get anywhere near one particular building, and you couldn't possibly get out of it. We had a fire emergency this weekend, and we were having a little bit of trouble with our repeater. That came right in on the repeater. So we just wondered if that station is working within the legal limits, or those stations that are around there, we can count them just like this. Thank you.
I'd say what you have is you have a classic case for an investigation, and that those sites can be looked at. Look, we have the power to go in and inspect and look at stations, okay? So that's a situation where that power should be invoked, and somebody who's doing an inspection, I'm certain you're going to tell me next is that you've already contacted the DOC and you've had somebody out, but maybe it needs to be followed up a little bit more on, and like, if you give me your name, I'm more than happy. So
see, we can't tell what frequency they're on. Sometimes you can, sometimes you can't tell what frequency they're operating on. But we know the location. It's that guy up there, or it's that guy up there. And could we make a complaint or an ask for those particular ones to be well,
yeah, I would say we're looking at. Sorry, go ahead.
If they're within the legal limits, they can do, but we would like to be assured that they are operating legally.
I can't see why we wouldn't be able to do an inspection.
Well, look, answering services and things.
We seem to suffer a lot, and I'm sure we're not any different than any other city in Canada, from willful interference by the local Yahoo who steals a 2-meter handheld out of somebody's car or whatever. I'm the president of the BCFM. We've got about 7 repeaters up on the local mountain here. And on at least 2 occasions, we've been able to actually find these people. We have names, addresses, phone numbers, etc. And we've talked to them. In some cases, we've talked to their parents and the problem's gone away. In other cases, they swear at us on the phone and hang up. What can you guys do to help us solve this problem? What are you willing to do to help us solve the problem?
I think this is a local question.
Yeah.
I definitely defer.
I haven't been involved with one yet. Now, let's get one thing out in the open to start with, is that the department on a whole, and myself included because I get these complaints too, are very appreciative of the work that's done by the amateur community to look after the bands. Okay? There is no way, we do not even come close to having enough manpower to look after the problems. So those problems that are solved outside where we don't have to come in, I mean, there's a great appreciation for what goes on so you can solve those. Those ones that don't, I don't know what's been done in the